Hi there, I'm Will Trackman. I'm the General Counsel of Mountain States Legal Foundation. I have with me here the Deputy General Counsel of Mountain States Legal Foundation, Sean Nation, and we are here to talk about a doozy of a decision that just came down. As you probably know, if you follow the Supreme Court every year, the end of June is sort of this mad rush to get all the big opinions out. And this year did not disappoint. This morning was like Hanukkah morning for me when I woke up to try to find out what the Supreme Court was going to issue. They issued three opinions, two of which were, fairly interesting cases, but not the one that we're going to talk about today. They issued affirmative action decisions in cases involving the University of North Carolina and Harvard University. Mountain States Legal Foundation filed amicus briefs in both of these cases. They were at first merged and consolidated, then unconsolidated when Justice Ketanji Brown Jackson joined the court, and then it seems somewhat reconsolidated for the purposes of issuing the opinion this morning, which is 237 pages. I confess to only having read 236 of those pages, so it's possible there's something I missed. Sean, I think maybe you've come close to reading everything. What's your first reaction?
As close as I can. My initial reaction is that this is a great opinion for the 14th Amendment. The Supreme Court, 6-3, with Chief Justice Roberts delivering the opinion of the court, held that the use of race as race in college admissions violates the 14th Amendment. It is a position that Justice Roberts has invoked many times, but now he was able to command a 6-3 majority. 6-2 in the Harvard case. Justice Jackson was recused from that case, as she was previously a board member for Harvard University. And really the meat of the case is a quote by Justice Roberts, where he held that the admissions programs, quote, cannot be reconciled with the guarantees of the Equal Protection Clause. Both programs lack sufficiently focused and measurable objectives, warranting the use of race, unavoidably employ race as a negative in a negative manner, and involve racial stereotyping and a lack of meaningful endpoints. Those are all very key elements for any use of race going forward, both in college admissions and quite frankly, in almost any other government program. The court upheld the use of what's called strict scrutiny, which is the highest test that the court employs. And it really means that any racial classification or use of race going forward is going to be very difficult for anyone to justify.
Yeah, I mean, it was interesting how forceful Chief Justice Roberts has been on race issues. 2 weeks ago, he decided an opinion in a case called Milligan, which we're not involved in, about voting rights issues. And there he held that Alabama had to gerrymander second African-American district. So it was really anyone's guess going into this morning where he was going to land. This opinion is as good as we could hope for. Sean, I think you pointed out that these elements about not having an end date, having been based on stereotypes, and having a negative effect on people who do not receive the preferences, that even though this case was about the University of North Carolina and Harvard, there's no affirmative action policy that I've ever heard of that actually meets any of these goals, because they're generally based on stereotypes about the fact that you can create diversity or recompense for past discrimination by giving a preference to all of the racial minorities who apply to your university. So even though this is about two schools, I don't think it goes anywhere from here in terms of affirmative action. Now, it doesn't seem like the case would prevent a university from saying, tell us all the ways that you suffered discrimination in your life. And then students could respond by saying, well, I've suffered racism. Is that your reading as well?
That is, and in fact, both the dissent and several of the concurrences make that point, that if a student has overcome racial discrimination, or quite frankly, any other challenge in their life, the Constitution does not prevent or forbid the university from considering that. And in fact, what it does prohibit is just assuming that every racial minority has suffered discrimination. The dissent would essentially make that argument that every minority group, because America is irredeemably racist in their eyes, has suffered discrimination. That is not what the majority found. The majority, I think, appropriately says, if you can point to something in your life that you've overcome, of course the university can consider that. But it can't just assume or stereotype that every minority in this country has faced discrimination.
Yeah. One of the concurrences in the case was by Justice Brett Kavanaugh, who was appointed by President Trump and famously had an assassination attempt on his life last summer, writing about a 25-year limit that the court had referred to back in 2003. In a case called Grutter, in a 5-4 decision, then Justice Sandra Day O'Connor said, "We expect that after 25 years, we won't need race-based preferences for college anymore." And so Justice Kavanaugh wrote specifically about that because it hasn't been 25 years, but he did say there's a temporal limit, a time limit on racial preferences and race discrimination, and cited to some of the even earlier cases involving affirmative action going back all the way to the 70s, saying it hasn't been just 25 years, it's been over 50 years that we've had race-based preferences, and the schools in this case make no bones about the fact that they see no end date. One of the things that Mountain States brought up in its amicus brief was the idea that the schools at issue are obsessed with race. So there may be in the background this 25-year limit, but if you were actually going to hold that limit, you would see some sort of weaning off of the use of race. But the schools are actually going the other direction. They're obsessed with race at every step of their admissions process, whether a person gets through the first round, whether a person has their personal statement read, that schools consider their racial demographics all the way through the process. And this is actually damaging Asian Americans most. So compared to Asian Americans, Caucasian applicants were actually getting something of a preference. What do you think, Sean, about the relevance of this decision to Asian Americans?
I think it's important, and I think it's interesting. The majority opinion points out that the use of racial classifications was essentially nonsensical. It made no distinction between a person of East Asian descent and a person of South Asian descent. It used the term Hispanic, which doesn't really have a definition, isn't particularly well defined. And again, Native American and Pacific Islanders were one category, but there's really not a reason why that's one category versus another. It also points out that there was no category for people from the Middle East or people from North Africa versus Southern Africa. So really, these arbitrary distinctions that the schools were making, yes, ultimately hurt Asian Americans the most, and Asian Americans were one of the primary plaintiff groups. And one thing it sort of pointed out is in creating these very broad and over-inclusive groups, the schools are just engaging in racial stereotyping. And it pointed out things that Asian Americans, particularly East Asian Americans, were considered to have less of a personality score than other groups. And it was to the point where Asian Americans would have to score, I believe it was 273 points higher on their standardized tests to have an equivalent opportunity as an African American. And, I believe that was specifically for Harvard, but, the use of race in a zero-sum college entrance game necessarily hurts some groups if you're helping another. And so what the court said is you can't do that anymore.
Yeah.
You have to consider the applicant as an individual. And if race has impacted their life, of course, that can be considered, but you can't just assume it anymore.
Totally. Yeah, I thought Justice Gorsuch's concurrence on this point was somewhat humorous, talking about how if your ancestry is west of Iraq, but not Africa, then you're white. On the other hand, if it's east of Iraq, then you're Asian, unless you get to the Philippines and then you start becoming Pacific Islander from there on. But if you're on the Philippines, even though you are in an island, that is still Asian. So you are grouped with the 60% of the world that is Asian American and which suffers of discrimination here in terms of personality scores, like Sean mentioned, and just generally having a higher bar to get into these schools. Justice Gorsuch also mentioned that there are cottage industries of college admissions consultants who will help families who are of Asian ancestry downplay that. So not using a middle name, for instance, making sure not to use a picture if that's optional, maybe taking off activities that look like they could be related to Asian culture in order to avoid the negative that comes with being identified as Asian in the college admissions process, which seems absolutely abhorrent to me.
Agreed.
Now, my plea with the decision, I suppose, is a little bit tempered by the idea that schools might try to get around this. Sean, do you have any reaction to the idea that schools might say, well, we'll comply with the letter of this, not the spirit of it?
I fully expect college admissions officers to continue to use a proxy for race, whether it's neighborhood, whether it's sports or something that they can find that correlates with race. I would fully expect them to engage in that type of discrimination. Maybe I'm just maybe I just don't trust university admissions officers.
You're a pessimist.
I somewhat, and for these highly competitive, highly selective schools, they're still going to use admissions interviews, and that is a way that, unfortunately, this sort of invidious discrimination can sneak in. At the oral argument, it was made abundantly clear that they didn't really care about true diversity. They just wanted photographic diversity, I think is how Justice Thomas referred to it. And I suspect, much like we've seen the California schools do, and I believe Michigan also bans the use of race, but we still see college admissions officers likely using race as a determining factor.
No, Chief Justice Roberts actually anticipates that to some degree by saying a school can't accomplish what we ban here today as unconstitutional through the use of strategic proxies. So a school couldn't say, well, we're not going to have direct anymore, but we will have indirect affirmative action by making sure that 20% of our class comes from a specific zip code in a specific city that has a heavy Black population. So there is something interesting there. Now, Sean, you're in charge of our Brigida litigation. It's a little early to ask you what the implications might be for cases outside of the academic context. What is your reaction initially to whether there might be some cross applicability given the broad scope of it?
I do think so. I think the opinion, the majority opinion certainly stands for the idea of a colorblind constitution, and that the way to stop discriminating about race is to stop using race. So I do think it will be used more broadly, and as in the Brigida case, which is an employment discrimination case.
Thank you. I should have clarified what Brigida was.
No, it's an employment discrimination case where the government discriminated against non-minority applicants to the FAA's air traffic control system. But I think there are elements of this decision that would be applicable as it stands for a race-blind and race-neutral process, whether that is in hiring, whether that's in school admissions, or just generally where the government action is involved. The government's programs will have to survive this strict scrutiny, which is a narrowly tailored approach to a compelling government interest. And there are instances where the Supreme Court has said, if you can point to previous specific racial discrimination in the past, then you can tailor a program to counter that, to rectify that. I think that is likely still valid, but it's not here. Neither of these schools argued, and in fact, they specifically disclaimed that this was any sort of recompense for past discrimination. I would expect some schools to take a shot at saying, we used to discriminate based on race. So now to correct that, we have to engage in affirmative action.
With different people that we didn't discriminate against.
Yes, yeah. Yes. I don't know that that will be successful, but I can foresee a college trying that. Yeah. Particularly in the South, where there certainly was historical discrimination in college admissions. That hadn't really been the case in 50 years, but I could see a school trying to say we're rectifying a historical problem. Yeah. Again, I don't know that it'll be successful, but I could see him taking a crack at it.
One of the other cases that we're litigating at Mountain States is called Young, the Colorado Department of Corrections. In that case, Josh Young, our client, was a rising star in the Department of Corrections, and the official training materials for his position were called Equity, Diversity, and Inclusion Training, and they contained these gross stereotypes about Caucasian individuals, perpetuating white supremacy, thinking of all African Americans using the N-word, and being fragile if they were confronted with ideas of racism. And we're in the midst of suing under Title VII, as opposed to Title VI and the Equal Protection Clause in this context. I was very pleased with some of Justice Gorsuch's dissent, saying that Title VI and Title VII are essentially the same language, and that you have to read the text for what it is. I thought it was interesting. He actually chided his former co-authors or co-joiners in the Bostock case. That was a case about whether transgender and gay individuals were protected by Title VII. And he said, "Oh, you were with me in that case when it was about textualism and it benefited gays and transgender individuals, but you're not with me when it's about textualism here and it benefits non-minority college admissions applicants." I thought it was ironic to have that part of his concurrence. I do think there might be some valuable sites out of that concurrence for our young kids, so I'm looking forward to litigating that. Well, it's definitely a momentous day. Good day for the Constitution. We here at Mountain States Legal Foundation pride ourselves on being the Constitution's lawyers. We look forward to talking to you folks again tomorrow, because the 303 Creative opinion is going to be coming down in the morning. It'll probably be the last day of the term. And so it'll be another one of those days where it's a mad rush to get things out. 303 Creative is a case we filed an amicus brief on in support of Lori Smith's right not to be forced to post same-sex wedding websites on the internet. So we think that she has a right not to have her speech compelled, and we will find out tomorrow whether that's true. Sean, any final words about Harvard and UNC?
I think this will make college admissions a lot more fair for everyone, and I think that can only be a good thing.
It sounds like we might have one question. You want to read it to us? Okay.
Yeah.
When it comes to the question is, will this help with unvaccinated individuals when it comes to the movie industry? So not this case. This case is about race and college admissions. On the other hand, there was another case this morning called Groff v. Joy, which we did not file a brief on. It was a religious freedom case involving whether employers must reasonably accommodate individuals who have religious needs. So that might be declining an exemption, declining a vaccine based on a religious exemption. So that decision could have an impact for people who have a religious religious objection to vaccines. Before this, employers had to prove almost nothing with respect to the inconvenience that would occur based on an accommodation. That'll change going forward because, as we all know, in a disability context, and if an employee needs a ramp or a differentiated schedule or a stool or a chair, that's generally something the employer has to provide. But that hasn't been the case in the religious accommodation place if you need like Sunday morning. So that will change. Thank you for the question. I think on that note, we will close. We will see you all again tomorrow. Thank you.
Tomorrow at noon.